reports coming in.
Yeah.
I think I'm not aware of the...
Right. So it's up to them whether they want to report it.
Yes, but if you you should ask them.
Yeah.
And really, because police have now this legal duty under the domestic violence decree, I don't think there's any problem with just sort of asking police if they've received such a report, because such an altercation may already have been reported,
Yes,
or
yeah.
by neighbors who have
Yeah.
called up and they say there's been a fight and things like that. So
Yeah.
you can always check with police,
Yeah.
and then that allows you. They'll come with this medical form.
Yeah.
Probably.
Okay. Yeah.
So, because the thing with the domestic violence decree being passed is we get a lot of cases that have started in court, and then the people involved, the alleged victim, alleged perpetrator, they write and say, we want the case withdrawn, we never wanted the person charged.
Yeah.
But under the decree, the police have a no drop policy, so they have to proceed with it.
Right.
And that's because, I suppose, the executive, the legislature, what have you, understand the dynamics of the relationship. For sure, they'll always want to withdraw.
Yeah.
They would always want to, sort of maintain the status quo when the purpose or our aim for our future society is that no one lives in violence.
Yeah. Yeah.
So there's just that,
Sure.
that
Yeah.
dynamic. But for the most part, it would come up when you're taking history anyway. If a assault case comes and it's domestic violence, all it means is that the courts will focus specifically on higher penalties, issue a restraining order, that kind of thing comes into play. Are there any questions about domestic violence or any cases related to that? Anyone's having an issue with?
No.
Silence means no.
Yeah.
Okay. All right. Okay. You also asked for motor vehicle accidents.
Yeah. I
Again,
guess
I've
my
been general because I wasn't sure.
My list was just because these are the things that commonly occur in the emergency department, and people are commonly asked to write reports about them. So there wasn't anything specific. It was, I guess, just to give people an overview on what they should be doing.
Oh, okay.
Yeah.
So for the most part, yes, you will probably, for an accident, if there's been a serious accident and the person is prostrated in hospital, police will have found out about it in some way or form. So they may have attended the scene and then they find out later that the patient has already been brought. Hopefully they bring a report form to you to fill out so that you have, contemporaneous evidence of what happened. But again, as I mentioned, if police then come knocking maybe the next day or a few days later, whoever was the attending can just fill out a basic plain statement form. So you just give evidence in that way of what happened, what treatments you gave, what injuries were there.
Yeah.
Because the, if the person has survived, they give a statement themselves of what happened to them.
Yeah.
That can be supported by your plain statement if a police report is not done.
So this actual medical examination form has to be filled out at the time. It can't be filled out later.
It's ideal that it's filled at the time because whilst you're doing the examination.
I guess I'm just asking if you saw the patient first and then say, I don't know, 8, 10, 12 hours later or the next day when you're on shift, the police officer comes with the report, can you fill it out then? Or
it's meant to be done at the time of the examination.
Yeah.
But if you've already examined the person, you may be able to put a note when you're writing down history and things, or even
that you're filling it out retrospectively from your medical notes.
You could just do that, from your medical notes.
Okay.
That's fine. So with motor vehicle accidents, clearly there's different charges if you drive recklessly or carelessly or dangerously, and in terms of if we see medical evidence of grievous harm, which legally has to be very serious harm or something that may permanently injure health, then that affects how we charge a person. But it would be filling out the same sort of medical examination form.
Yeah.
Okay. You will also probably have police coming to you with suspects. This may happen a lot. Well, I assume it happen a lot because in the investigations they've identified a person as a suspect, they then arrest the person, they bring the person in, then they question them under caution, which is they give them their rights, and then they record this interview with them. And this interview, for the most part, in most of our cases, is a crucial piece of evidence because it's a confession. Now, we can only admit this confession in a court of law if we can prove, beyond reasonable doubt, that they were treated fairly, the confession was given voluntarily, they weren't threatened, they weren't oppressed, they weren't, injured, harmed in any way. So what has occurred is that police will sometimes bring suspects for proof of their condition before, during, and after the actual caution interview, just to support them later on when the accused person, if he happens to want to make an allegation that he was assaulted, therefore confessed due to the assault, to protect them and say that he was in fine condition, he wasn't mistreated, we took him to a doctor, he was checked out, so on and so forth. So when this matter comes to court, if a medical report has been done on the suspect at the time of the interview, it really helps the court determine in relation to whether the confession really was obtained under assault, things like that. So basically, if police are coming to you asking just to do a general checkup of this person, what you just need to check is their general physical condition, ask them if they have any complaints, and you may want to know their demeanor and things like that, if they seem scared, or if they seem drunk, or if they seem completely out of it, anything that may affect the fact that they can talk coherently, they're doing anything voluntary with police, that's what we would like to see with these reports. But if the suspect has requested the report themselves, then most likely they'll come to you in your examination room and they'll say, I was assaulted by police. Ask them for specifics, just like you would do any patient, of course. Record their history and then do the full examination as you would for any other patient. Okay. We also have to talk about preserving the chain of evidence. For the most part, the evidence is the report itself. So you fill out the report as best as possible, sign and initial each page. There's actually a section where you're supposed to initial each page to prove that you filled out the report in its entirety. Any additional pages that you add should also be initial, signed, dated, and numbered. And the report itself then becomes this piece of evidence. As I said earlier, it can just be submitted as evidence under law. So it should be given back to the same officer who handed it to you. This helps in proving the chain of causation, just the chain of evidence. The less people who deal with something until it comes to court, the better. So if the medical report was given to you by Officer AB, you filled it out, signed it, everything, did everything you needed to with it, give it back to Officer AB. Officer AB should then take it to the police exhibit room, put it in an envelope, label it, have it in the exhibit room until it's needed again for trial. Then Officer AB goes, takes the medical report, comes to court, produces it to the prosecutor. There you go. That's the original medical report that was taken 3 years ago from Dr. CD. Ideally, that's the case. As I also mentioned, you will also get a statement. They do require that you make a plain police statement, just describing that you were the examining doctor, what you did, or if you want to just annex your report as part of your statement, that can be done as well. And just what we've already discussed about having duplicates. So I know that there should be a copy for the hospital, and if medical officers want to have their own copies, it's probably a good habit because you may be called to give evidence about it later. Or, it does go missing from the police room, a police exhibit room, and now I know it can go missing from the hospital as well. Yeah. So in vaginal swabs, as we've already discussed, that just gets given back to the same police officer who hopefully will take everything all together. This officer then takes it to the forensic lab, the police forensic lab in Masova. And that you don't really have to worry about that after that. So one thing though is, definitely as ER doctors, you would have people coming in with serious injuries who have to be prepped for surgery and things, and then you cut away their clothing or whatever they may be wearing. I've been asked by police to say, as much as possible, try to preserve clothing. So, and anything that the victim may have been wearing or carrying or anything of that sort when they come into the ER room, because this can become evidence later. So they say that a lot of doctors simply bin the clothes that are bloody or muddy or whatever the case may be. So that try as much as possible to preserve it for police. Is that
That's really why I made the point so that you can make the point to them. Because it is something that unless you've been told, you don't really think about when you're dealing with a severely injured patient. So it is important to just get some kind of bag and put all their clothes in if the patient moves, and try and give it to a police officer as soon as you can, because again, the more people that handle it, the less robust the whole chain of evidence is.
Yes,
Yeah.
that's true. Yes. Although one of the CSI says told me they will go digging into the bin, but of course then it could have been subject to so many other things
Yeah.
from the rubbish itself. So if doctors could preserve this stuff as much as possible, they would really appreciate it. Especially if the person goes on to maybe pass away
Yeah.
later on, and if there's blood from the perpetrator or any sort of DNA evidence that they may be able to recover, it could help with the investigations. Okay. So it's also important to note that if during your examination you're taking samples, blood, whatever other bodily fluids, as the case may be, that the patient has consented, that the consent is explained to them, that you're going to take this blood from them, you're going to take these swabs, or whatever the case may be. There's some doctors, we're very friendly people, so police come to you and say, oh hey, just come and withdraw blood from this person, and some doctors actually go on to do it. Please be careful about ensuring that the patient has given consent. If no consent, don't do it unless there's a court order in place. As I was told that some doctors, being very overly helpful, they just go on to do whatever police is asking them to do. But just be mindful that if it's about taking samples from someone, like a patient, then it has to be by consent. There's also an issue, procedurally, dead bodies, the person is obviously dead, maybe even partially decomposed, they're brought into the ER to be certified dead before they can be taken to the pathologist. So that's just another thing. You will be the first port of call to clinically certify a person is dead, and then they take it to the pathologist. Apparently there's some issues if the bodies decompose and things like that. It's just a matter of procedure, so I was asked to highlight that. A good habit that you may want to start is having a dispatch book in terms of when you give over your swabs, your medical reports, whatever it is, and have the police officer that you give it to specifically to sign, date, have his badge number, his rank, his full name, and the station that he's at and where he's taking it. Just to sign it out. Just so you can safely say, I dispatched it to this person on this date, so on and so forth, and where it went from there, you have to ask that person. Any other questions about preserving evidence? Okay. Now, I hear that doctors really hate coming to court and giving evidence. Really, you would be asked to give evidence if the defense counsel are objecting that your medical report be tendered by consent. If your medical report cannot be made sense of and you have to come and explain it yourself. Or sometimes you're just summoned as a professional doctor, as a medical expert, to talk about another person's medical report, or just to actually be a factual witness if you happen to be present during the examination and they want to know what you remember about their demeanor, what you saw firsthand, so on and so forth. So first of all, if it's a case from our office, we always issue summons, which is just a blue form which some of you may already be familiar with, detailing the date that the trial will happen, the case that is related to. More often than not, you probably won't recognize the name on the case because it's the perpetrator. So once you get a summons, just try and get as much detail as possible of who's running the case. If it's us, the prosecutor should get into contact with you, and then you have a brief witness conference going over your report again, your statement, preparing for court. These are very general things about court because I wasn't sure who has experience going to court or not. So it's just very, very basic things.
How many days? Sorry.
Yeah.
How many days do you? Is it minimum for you to appear in court if you're given a summons? Like for a summons to be given to you. Like usually, sometimes they call you a day before, but we are told not to go unless it's 14 or 21 days before the court case.
Technically, once a summons is issued and served to you, you have it's a court order for you to appear. So I know that practically no one likes to be surprised last minute. I think that's that may be just a policy thing because there are circumstances where it becomes evident when you're in the middle of trial that such and such a person is an important witness. The court will then issue a summons then and there. And then the summons has to be served to such and such person, and then they have to appear in court the very next day. So there's no time limit to when you receive a summons. It's not the case that you should only if you receive it 7 days prior, then you can come and be witness, technically all that has to happen is you're served with this summons. You see, if the date is for tomorrow, unfortunately you have to appear in court. It's a court order. And breach of that can result in you being arrested and brought to court.
I think this might be something that we might need to get you back for more of a discussion session on, because I know there's a number of people who aren't here who've been to court a few times and they've probably got questions for you.
Okay.
And obviously, in the interest of time, it might be not able to address all of those questions now. But I know some of the doctors who work here, they've been to court quite a few times,
Okay.
and I expect they would probably like to ask you a few things. But good to know some basics anyway.
Yes. So unfortunately, all that has to happen is that you're served with a summons. But for the most part, the court and prosecutors understand that you have, obviously your own jobs to do. With doctors are normally given a lot of leeway in terms of trying to fit around your schedule. When we summon doctors, first of all, for our office, summons should go out 3 weeks before trial at the least. And then we try to meet with the doctor and ascertain what the best time is for the doctor. Doctors are witnesses that are given all of leeway by the court, by us, by defense counsel, because we all understand that you have other pressing matters that you have to attend to. So, from my experience and from our office, if a summons is coming from our office, you just call up and you liaise with the time that you'll be available to come. And we always will work around a doctor's schedule for the most part, as much as we can. Because a summons can be, for several days. A trial can be a 2-week trial, even if it's a 1-day trial. If it's a 1-day trial, we will ensure that we free up a time where you can come. So if we have 10 witnesses and you say you can only make it after lunch, we'll lead all the other witnesses first, and then our medical witness can be the last witness or whatever it is. But if it's a couple of days, you don't have to come every single day. Once you come and give evidence and you're excused by the court, then you're free to go from there. So you just basically liaise with the prosecutor in terms of when you can come to court, and we always work around doctor's schedules. And we always try to get summonses out and give at least 3 weeks notice to all our witnesses, 3 weeks before trial, that this trial is coming up. But there may be cases where, you're the only person who can give evidence of a matter, and you can just be summoned, in the morning to give evidence that afternoon or something like that. The only thing is, if they are able to serve you with a summons, then of course you have no obligation to come. Once you're served with a summons, then it's a court order that you have to come to court. So coming to court, it's for witnesses. Apparently, it's a very horrible experience, but the key is just to prepare. So court dress is formal. In terms of the order of questioning, whoever is calling you as a witness will ask you basic questions first, leading to whatever they want you to give evidence about. Then your evidence is tested or cross-examined by the opposing counsel. The court may also ask you questions as well for clarification. So if you come to court, you notice the first thing, for the most part, that you'll be asked is all your qualifications. The reason this is done is because in a court of law, evidence should only be given on facts, or factual matters which you can talk about. If you saw it or if you personally experienced it, then you can talk about it. You can't talk about what someone else experienced. That's just a rule of law. The only exception is with experts who come and give an opinion, which the court will accept as a professional opinion that can lead to a determination of a fact. So this is why the qualifications are discussed first and foremost when you take the witness stand, because it has to be established and the court has to give an indication that yes, you have the qualifications as a medical expert, and you can then give an opinion about something to do with medicine. So if the other opposing counsel has no issues with your qualifications, then it can go much quicker, and you just declare a medical expert capable of giving opinion from the start. So, as I mentioned further on, you either come as a factual witness, how you made your report, or talking about your report, what you saw about the report, how you observed, or saw, or heard, or felt this and that, or you can be asked to give a professional opinion as far as you can in terms of your expertise about certain scenarios relating to the case at the trial. So just basically, it's a nerve-wracking experience, but generally just answer loudly, clearly, truthfully. It's important to keep calm. I've seen cases where cross-examination is a harrowing experience, and the whole purpose of cross-examination is to throw a witness off their game. So you have these doctors being very argumentative, and it's not a good look at all. Just because you're being observed by the court in terms of whether you're a truthful person, and for the most part, that means being calm. So just ultimately you're just there to assist the court. If it's about your medical report, then talking on your medical report. If it's about giving your opinion as an expert, then the scenarios will be given to you, and you then, based on the scenarios given to you, form an opinion and express that to the court. Just a few, so this is basically the end of my presentation. I know I've gone over time. But in terms of filling out medical reports, it's a basic form that should be filled out as much as possible and with much detail as possible. As mentioned, it becomes a piece of evidence in our courtroom. And also, the fact that you may have to refer to it many years after you've actually done the examination is important, just to give you an idea of how to fill it out. In terms of being called as a witness in court, it can either be about a case that you specifically did an examination on, or it can be giving an expert opinion about a certain case that they want your expertise on. And if you are called as a witness to court, feel free to always liaise with whoever is running the case, the prosecutor, so that you can prepare as much as possible for going to court and what you'll have to give evidence about. Right. So that's the end of my presentation. The only thing is my colleague will just go through a few sample medical reports and just a few issues that we picked up from some reports. Do we have time for that?
Probably maybe a couple more minutes.
Okay,
just Ali's happy to go home, that's all.
Yeah, okay, sure. So
yeah.
Just very quickly, we'll just go through a few samples. Don't pay any attention to the names, just focus on what we're trying to do. Okay. I'll ask my colleague to take over this one.
Basically a report of an underage person, but the report that the person had lodged was that the person was assaulted, and this doctor had in fact noted that there was tenderness on certain parts of this this person's body, but this was not indicated in the appendix. It becomes in this case there was no bruises noted by the doctor, but what was important for us to note is that there was tenderness noted. So this will reflect on the charge that the perpetrator may face. It may be assault, or it may be assault causing actual bodily harm. So where there is no such harm noted, then the charge may be different. So in this case, wherever the tenderness was, it was very, very important for the doctor to note where exactly on the part of the body the child or the person who was being examined actually had the tenderness.
Lost someone.
Okay.
I think Nandi's gone. That's alright, you can keep going.
It's recorded.
Right here.
Ah, there you go.
That's basically one medical report.
Okay, so
Maybe escape again.
no, there you
That was pure fluke.
go.
Thank you for waiting, everyone. This is just another form where we have noted something very inconsistent. The first thing that I'd like to highlight is that nothing is clear, as you can see. We've had a look at the one in our file, and what was happening here is that carbon paper was being used. So it appears that two forms were being filled at the same time, and carbon paper was put in between. What had happened is that everything is everywhere on this page. We really can't figure out what the name of the person is, if there is a signature at all. So that was one thing about that. The examining doctor also had forgotten to put initials at the end of the page, like my colleague has highlighted. Now, apart from that, if you note the handwriting on this page, this handwriting is right from the beginning of this medical report. Now, if we go on to this page here, the handwriting has completely changed. Now, there is no indication, there was no supporting statement as to why the handwriting was changed, and if there was a second doctor also observing at the same time, as well as examining. So, it will be very, very helpful if the doctors specify if there's been a change, and if they can, there may be various reasons for that, but if a supporting statement is given, it will be very helpful. I'll just go to another.
So I have a question for that, for this police report. It seems like that the police report was filled in something like Nandi Hospital. The patient was transferred to Lotok Hospital. I think the gang from Lotok Hospital must have filled that part of the page. So my question is, should there be, I think there should be two police forms. Because when I first started, it started off as them telling us to fill only the front part, and then the back part will be filled in Lautoka. But then over the years, they started to change, where you fill one in Lautoka and then another police report will be filled in Nandi.
Okay, so that's how.
So I think that's what happened here.
So that's okay if you cannot complete the medical form, but there must be then a supporting statement to clarify why it was not completely filled out, so that you are in the clear. Does that help?
All right. But just to clarify, should the same police report be used again for the same patient in the referring hospital, or should there be another police report be used in the referring hospital?
It sounds like it should be a second one if it's a different doctor, because you can't be accountable for what someone else writes, so you can only be accountable for what you write on your form. So I think if you can't complete it because the patient's heading out the door to Lautoka, just write, I have completed this as far as possible, patient now transferred to Lautoka, and they should fill out another form.
If it becomes necessary to use the same form, again, you could just note it on the, just attach a page or statement to the medical report itself. But this is why, again, filling out a police statement is important, because you detail in your police statement and sign the police statement of what you actually did or what happened. Like if, now that you're explaining that they say fill out the initial part and then probably OBGYN takes on the next part, is that what you're saying?
I'm thinking more of the scenario or in Nandi where you might get a really severe trauma in, and that's beyond the capability of your hospital, and they go in a rush in an ambulance to Lautoka. So I can imagine there would be a time pressure there.
Oh, okay. There should be hopefully another medical report, otherwise just supporting statements, as my colleague has said, just to make sure everything is understood. Because when we present this in court, it is very confusing. If we're to presume, the person who has signed and written that they did the report, then how do we explain that the handwriting suddenly changes? And if your name was the only name on there, on the report, and you just did the initial checkup, so you can see how you can get into trouble, because you'll be summoned to court and you have to explain what happened with this medical report, and you can't really say. So supporting statements are really important.
Okay, we'll move to another medical report. The problem that we faced with this one was that firstly the handwriting is illegible, and secondly that the medical report was not completely filled out. This is a photocopy. If you are seeing darkened areas, it's just because of the photocopier. But basically, I'll appreciate if you focused on the handwriting. As I'm scrolling down, you can see we are unable to make out some of the things like the history related by the patient. Some of the things there are not clear. Apart from that, when we go down further to examination of patient, especially the physical examination, specific conditions, it's absolutely not clear. So this is just one of those examples where handwriting necessarily needs to be clear, so that we don't have to call up the doctors to bother them. If it's clear, then we can render an opinion on it, and the doctors don't have to be called up. Another thing about this medical report was that part C, as we can see, is completely blank. This was a supplementary report. If there's nothing to be included in the supplementary report, it can be indicated. Perhaps a nil could be written, or no further comments. But here, consequences of injuries and prognosis, any matters worthy of comment, name of the doctor, qualifications, years of experience. This was very crucial for the doctor to fill out, but failed to do so.
This is an old medical report form, but the point, it still happens with the new forms. People don't fill out all the sections. Because even if you note nothing or nothing is relevant, at least put something down there so we know that you've attended to all sections of the report.
Okay, very quickly we'll just go to one last form. This form, the main issues are that there is no consent part filled out. Let's scroll down to that. This is the one I'm talking about. No name of the doctor, there is no signature of the patient, there is no interpretation specified. So in this case, it's really necessary that consent part is filled out. A personal experience that I've had with one of my cases is that there was a child involved in a matter of sexual assault, and the mother was present with the child when the child was being examined, but the examining doctor had failed to ask the mother to give consent at the time, and before the examination actually took place. So because of this issue, because it was overlooked, we are now going to have a trial within a trial, only to determine whether this medical report is now admissible as evidence. If the signature of the mother was put there before the examination actually took place, a lot of time in court would have actually been saved. So it's, as you can see, it's very, very important. In this portion, you can see that years of experience has been missed out by the examining doctor. The contact number as well as the extension also has been missed out. It's a very minor detail, but sometimes it's just very helpful for us when we try to contact the doctor to figure out a time for a witness conference. It's helpful just to directly call the doctor on the extension rather than going through being transferred to different places, different departments in the hospital before we actually get the doctor. A similar thing in this part, summary and conclusions are missed out. It's also a very important part to fill out the examination at the time that the examination was completed. Summary and conclusions have been missed out in this one. I just have one more medical report to show you. This one that we were of the opinion that has been done very well, so we thought of using it as an example. As you can see, the first page is filled out by the police. The second page, there is consent, there is signature, and there's it has been explained to the person in the English language. Portions that were not relevant has been crossed off. As you can specific medical examination details are there. History related is specifically stated. The impression of the patient is stated. The specific medical findings, all the portions, as you can see as I'm scrolling down, has been filled out. And where nothing was to be noted, deal is written. The time it was concluded, time it actually commenced, the date of it, and specifically the diagrams. Things are left and right are specifically noted, and places where the injuries are has also been noted. Yeah. And as well as the doctor's initials, it was on every page. That was helpful. So that's all I have.
That's all we have for you today.
Great. Thanks very much for coming.
Thank you so much for paying attention to us.
No, that was great. So much to cover in there. So I think even for those of us that were present, it'll be good to look over that again. I might grab a copy of the PowerPoint as well. That's all right. Yeah, it's such an important area for all of us. So
thank you for
really
inviting
great.
us. It's good that we've had an opportunity just to talk with you guys as well and note some of the issues. And hopefully we've answered your questions. If not,